All right, thank you. Our next speaker will be Derek Key. He's with Key Mary Law. He's got over 40 years of experience in corporate real estate and commercial law. Derek is widely recognized as one of Canada's leading legal professionals and trusted advisor across Prince Edward Island. Derek will be sharing valuable insights. I gotta put my glasses, it's getting too dark here. Too much work trying to read this. Yeah. Derek will be sharing valuable insights on key legal considerations for Woodlot owners, including topics related to property, governance, strategic planning. His extensive experience working with planning boards, tribunals, and all levels of court brings a unique and practical perspective that will benefit attendees across the courtroom sector. Derek is a recipient of the Order of Canada, the Order of Prince Edward Island. His dedication to his profession and community makes him an outstanding addition to this year's speaker lineup. So Derek, very involved in Woodlot. He was a runner-up for Woodlot Owner of the Year last year. And I'm a former civiculture worker, I'm retired now, so I did a lot of work on his properties. So a lot of biodiversity, so a lot of plantations. With the Forestry Commission, he took us on a tour there. Maybe we can organize the Woodlots to go out and barbecue at his place sometimes. He's got a real nice woodlot and a lot of different activities going on. So I'll present you Derek.
Good morning. This lectern was built for Marcel, not for me. Are we good? Everybody hear me?
We need a light.
No, okay. I'm gonna make it up anyway, so don't worry. We're good. I want to thank you for inviting me here today to share some thoughts about that might be of some interest to you as woodlot owners here in the province. As I indicated to Sarah when she reached out about what topics might be, I said it'd be fairly easy to decide because we focus primarily on those things that clients asked about over the last number of years and those things that appear to have the greatest concern to them. In particular, those types of questions relate to occupiers' liability concerns, question of whether or not we should have liability insurance on our woodlots, intergenerational transfers of our properties, the limited options available without triggering tax, the totality of risks associated with land ownership, and a personal bugbear of mine, and that's the overall lack of action with respect to the forestry management report that was completed by the commission. Before I get started, and I'm cognizant of the clock and the fact that I stand between you and lunch, Marcel said, try and be brief. We're running behind. I was here when he was supposed to call the meeting to order. You did a great job. Oh dear. Alamo 1988. There was an overriding concern in this province by all landowners arising from court decisions throughout the country that where property owners were being held to account or responsible for injuries or damages to people who went on their property, either as trespassers or as guests, or invitees, or licensees, or any other legal term you want to use. In fact, the seminal case was a Supreme Court of Canada decision that came down in the early 80s, 1982, I think, where there were snowmobilers who had entered upon and on private land that was posted as being private property and with no trespass. When they ran into a gate, one of the snowmobilers was decapitated. Ultimately, the property owner was held to be liable. The same would have been held true in Prince Edward Island at the time, under the circumstances. If you had a clothesline on your property, if you had strung a barbed wire fence, if you had an uncovered well, even potentially a low-hanging branch, you would have been held liable for an injury that occurred. Now, there were enough of those decisions that the legislatures across the country said, let it be light. Simply didn't make any sense to find landowners liable for many things over which they had no control. So in this province, in 1988, introduced the Occupiers Liability Act. Now, the legislation was designed to primarily protect landowners from people making claims against them. So since 1988, the law in Prince Edward Island is favorable to woodlot owners, as most people using your land are there for recreation purposes, and under the legislation are presumed to accept the risks. Section 3 says that you have to take reasonable care to make sure that people are reasonably safe. Section 3 sub 2 indicates that duty of care applies whether the danger is caused by the condition of the land or by activities carried out on the land. The key for those of us who are rural landowners in Prince Edward Island is in section 4.1, where your duty drops to a very low level as it presumes that the risks were willingly assumed by the person entering upon your land. However, you still have a duty of care not to create a danger with the deliberate attempt of causing harm, or if you act with reckless disregard. So what's all that mean? A person is deemed to assume the risk on your rural land insofar as if they enter your woodlot, in this case, to hunt, or to ride their ATV, or to walk, and they're not paying you anything, the law treats that person as having accepted the risks associated with the land. So if they trip on uneven ground, or you run into a stump, or you get hooked up in a barbed wire fence, or whatever the case may be, the law says generally that risk is theirs, it's not yours. Your obligation then is to not create a danger and to not act recklessly. So in that early 1980s decision, Supreme Court of Canada decision we talked about with the snowmobilers, they ran into a gate and one of them was decapitated. What happens under our legislation under those same circumstances? Interestingly, That's the cool thing about the law, is that there are always little quirks. In that instance, the gate was painted white. My guess would be that under our legislation, the court, in the same circumstances, would say, well, there's other logging roads or side roads or trails or whatever nearby. We know they're commonly frequented by snowmobilers. So even in the context of PEI's occupiers liability legislation, the fact that you painted the fence or the gate white may be seen as creating a danger. If that was the way that the court viewed those circumstances here in Prince Edward Island today, you'd have to ask former Madam Justice Key whether or not she would hold you responsible. My guess is she probably would. So you have to be cautious. The other interesting one that relates to our ownership of land is another Supreme Court of Canada decision that is involved, in that case, the property owner inviting a guest to their property for a visit. In that case, the driveway to the property was very icy and slippery. The freezing rain and icy conditions had existed for several days. The owners, through that period, did nothing to either sand or salt. They disregarded the icy conditions. The guest slipped, fell, and was injured. The Supreme Court of Canada says the test is you have to take reasonable care in the circumstances. The icy conditions were foreseeable. They had existed for several days. The owner took no steps at all to reduce or diminish the risk. The owner was held liable. Last one, PEI Supreme Court. Involved cattle penning event. You're probably all familiar with it. It was held at the Eastlink Center. The plaintiff was a volunteer who was working the gate. The rider on a horse slammed into the gate. The gate swung open. The plaintiff was injured. The plaintiff sued multiple parties, including the organizer of the event and the owner of the premises, the property owner. The court acknowledged that the Eastlink Center was the property owner, but the court also said its role was so limited as the property owner, it only provided the space, the basic maintenance, and access to the paying customers. The actual event was run by someone else. The owner of the land, in that case, could not be held liable when they did not contribute in any way to either the injury or the accident. Perhaps a harder one to reconcile with what we just heard, but again, that's the interesting way that the law works. The takeaway is that our exposure as landowners goes up if we charge a fee, if we specifically invite people onto our land, if the person is there for some reason other than recreation, or if we create either a known hazard or we ignore hidden dangers. It's in those circumstances where the courts are going to find responsibility. So if you happen to string a wire, or you put up a hard-to-see fence, or you fail to cover a retired or open well, Each of those would be viewed as a hidden danger, and you'd probably be held responsible. Part of the problem, and I'm very interested to hear this morning the discussion on insurance. Part of the problem of discussing liability insurance to protect you as the owner is that it generally costs a lot of money. But you have to weigh that against the fact that you could be sued. And once you're sued, you have to come hire somebody like me, pay me a ridiculous amount of money to defend you. Because while I'm nice, I'm not that nice. And I'm going to get paid for trying to keep you from having to pay the person who got injured. So your challenge is, do we simply accept that risk and not have insurance, or do we pay liability insurance and move on from that? It's a tough call. I'm thrilled to hear that there may now be a new and better opportunity for all of us to protect ourselves through a large enough group that liability insurance might become reasonably affordable. Because there is certainly risk. Don't create hazards. Address obvious dangers so you know about your land. Don't generally charge people a fee. Be cautious with organized use. That's another one. Basic signage sometimes helps. Enter at your own risk. If you know you got trespassers, you're not putting up signs to keep your neighbors out. But you're going to warn them that they come on your property at their own risk. May not be the difference between success or failure, but it won't hurt. You're not expected to make your woods safe. You are expected to make them not dangerous. Ownership of the land is fraught with risk. That's only one of the risks. We've all watched the definition of wetlands. Interesting to hear the discussion on that this morning. Expand and shift over time. Robbie, I'm so glad you're here. It's become that it's very unclear, even to those of us who are most diligent in trying to observe the law. Oftentimes, the Environmental Protection Act and its regulations, or the Planning Act and its volumes of regulations, fail to make clear even the simplest of concepts. Who could have imagined that a building lot approved only a decade or two ago would become a wetland because the government chose to put a pipe across the road to drain that field, and your approved building lot's now a wetland? Who would have guessed that? Who would have guessed that an 85-year-old golf course was a golf course up until 2 or 3 years ago is now wetland? Like, these are shifting considerations. I would argue that while we get cranky at those who try and enforce those regulations, all with good intentions, the ones we should be cranky with are our legislators who improve the language that goes into the legislation and the regulations. Because if they can't make it clear, don't send those poor sods out there to try and enforce it, because you're going to end up into a mess. And as a landowner, that's fraught with risk, because it costs you money. Same issues arise. We're talking at the back of the room here earlier. Same issues arise when dealing with activities within buffer zones. We're all familiar with buffer zones. If I was to pass around a piece of paper and ask every one of you to write down, where's the ordinary high water mark? What does that mean? If there's 120 people in the room, we get 120 different answers. Because nobody seems to know. I've got a case on the go right now where I've had to hire 3 different surveyors, and they're supposed to know. And every one of them has given me a different answer. Where's the ordinary high water mark? So as a property owner, and I'm going to be charged for having done something within the buffer zone that starts at the ordinary high water mark. How do we determine where that is? We need to be clear. Otherwise, as a property owner, you are at risk. I also want to talk to you about some ideas. Oh, lunch. If I start to see some of you looking that way, I know it's time to quit. I also want to talk to you about some ideas for your consideration with respect to the risks that arise from transferring your property. Whether it's to partner or spouse, whether it's rolling it into the company, whether it's an intergenerational transfer where you want to pass on to your children. Generally, there are risks associated with that. So one of the risks that's associated to any capital property, and that includes real property, whether it's woodland or agricultural land or recreational land or an apartment building, doesn't matter. There's a tax burden that's created over time. So even though you continue to pay your real property taxes every year, fire dues, maybe insurance while you own the woodlot, there's a consistent, quiet accrual of capital gains taxes that are being added to the value of your property as it appreciates. There's a clock ticking. Preparing for that risk and the eventual obligation to pay that tax is one of the challenges of being a property owner. It's just one more. I'm not an accountant, and I don't pretend to give tax advice. But I can tell you with assurance that at some point in time, irrespective of how you choose to dispose of that property, including gifting, and we'll talk about that in a minute, you're going to pay tax. You or your estate. We're going to teach you. So let's assume that you bought your woodlot and you paid $50,000 for it. Forget about that situation where your father gave it to you and you received it for nothing, because in that case you have a capital cost of 0. Let's assume you paid $50,000 for it. And because of the work you've done on it, because you've had somebody like myself come in and do a bunch of commercial thing, or done some great silviculture work, or you have done great forestry management on your property, or whatever, together with inflation, your property is now worth $100,000. So you, in our example, we would gain $50,000. So if we forget all about the possible exemptions and you might be a qualified farmer, you might do this, you might do that. The general rule is that 50% of that gain is taxable at 50%. So if you sold your property for $100,000, your tax bill is gonna be $12,500, 50% of 50%. If you're over 65, so plan on that. Checkbook's out, CIA is looking for you. If you're over 65, that would include some of us in this room, there's a good chance that you'll lose your old age security for a 12-month period because of the bump in income from the sale of that woodlot. So, unless you transfer your woodlot to your spouse, for which there's an exemption, and you choose to transfer your woodlot to your children, even as a gift, the government determines that it was sold at fair market value, and you still owe $12,500. Those exact same calculations apply in the event of death. The federal government says 1 minute before you're dead. What a pleasant thought. You can just imagine what Mrs. Key and I talked about home. 1 minute before your death, you are deemed by the federal government to have transferred all your capital property at fair market value. All you did was die. But the federal government says you are deemed to have transferred your capital property 1 minute before your death at fair market value. So if the beneficiary in your will is your spouse, there's a deferment, so it rolls over to your spouse, but that's it. As soon as it goes to the next generation, or to whoever you wish to gift your property to, that $12,500 bill comes due. Just because you died. So what are some of the potential considerations for how to avoid that kind of thing? Some people own their land in a company. Of course, you die, the company doesn't change, it's still there, it still exists. There are some issues, but it's a way to defer further that tax. One of the problems is that if you've owned the land for a long time and you want to roll that land into your company now and it's worth $100,000, you're going to trigger the capital gains tax anyway, and you're going to pay the $12,500 even though you roll it in your own company. Had you bought the land in your own company, then of course you're going to avoid that for as long as you want to avoid that. Till CRA chases you down. Anyway, it's an option. A trust works the same way, but again, if we're sitting here having this conversation, it's probably too late to roll it in, unless you think there's going to be a great appreciation and value in the future, in which event you can defer the tax on that appreciation by rolling it down. Don't trigger the tax to today's value, but you can at least defer future. So there's options. Some people make the decision to transfer their land to the Island Nature Trust or the Nature Conservancy of Canada or through some legal gift or whatever the case may be. That can avoid the capital gains tax. It also transfers your control of the land. So the land is no longer yours. It belongs to whoever you gave it to. So you have no say over it. I had a long conversation with the folks at Island Nature Trust, inquiring about life interests and other ways to perhaps maintain some say over your land. At the end of the day, that I'm comfortable with any of that stuff. So there are some relatively simple devices that folks can use to try and defer the tax. Some people add a joint title holder. you can manipulate the value, you can do all that kind of stuff, none of which actually works, nor is it a very good idea, but, you do that. At the end of the day, you're gonna pay the tax. It's a risk of owning the property, and whether you're gonna pay the tax because you've transferred it with warm hands while you're alive, or whether you transfer it with cold hands after you're dead, same tax is gonna apply. Every situation is unique, every family is unique, every piece of land is unique, every circumstance is unique. So I'm giving you an overview. Talk with your accountant, talk with your lawyer, talk with your family, your financial advisor, talk to your next door neighbor, get the best advice you can at the coffee shop, and go for it. That's it. So to wrap up with 7 minutes before lunch, Marcel. I had concern about what happened to the final report to the Forestry Commission. It was submitted to government on the 8th day of October 2024. To be very clear, we have Mrs. Key and I have a fabulous relationship with the forestry folks. They've been an exceptional support for the last 25 years. We've had the benefit of guidance from multiple forest management plans that we have for our property. We annually do our best to follow the guidance and advice that was set out therein. Admittedly, both Dorian and Fiona upset those plans somewhat. Upset the schedules. Didn't upset the plans, they just upset the schedules. Didn't change the overall objectives. We've had the opportunity to participate in some of the public sessions with the commission folks, provide some input, share lunch with them one day at the farm, as Marcel referenced, and overall found that they had done exceptional inquiry and done an exceptional job. It was disappointing then to hear the silence in return from government. Might have been helpful for government to indicate what sections were acceptable, or what sections weren't, or what sections should have more work, what sections should have further study, what recommendations they disagreed with, and why, or how government might plan to address some of the things that were set out within it. How about the shortage of hardwood seedlings? Anyone driving along Route 2 or anywhere else in the province can't ignore the challenges that we have in the forestry sector. Add to the destruction of Fiona the continuing damage being done by spruce beetle and other pests. You have to ask, what's being done here? I have my tiny little piece of the universe, and I do what I can, and you have your tiny little piece. You do what you can, and you have your tiny little piece, and you do what you can. But who's looking after it, other than the big guy? And I don't think in this case we should have to rely on the big guy to be the only one looking after us. This is a responsibility of the government, and I think they at least have to talk about it. It'll be very, very important, in my opinion, for the government to articulate clearly its goals and objectives with respect to a new forest policy before very much more time goes by. But as we've talked about with the risks associated with land ownership, 4 minutes, the risks associated with land ownership, whether it's occupier's liability or some regulation or law that's unknown or unclear to you, or triggering a tax burden that we've not either prepared or planned for, I suppose the government also sees risks in making plans or allocating resources that may be supported by some of us, but perhaps may be offensive to others. I got that. So, I guess to end, I would share with you my thought that good management and leadership is always accompanied by risks. Whether you're responsible for the forestry division in province, whether you're responsible for the province as a whole, or just for your own woodlot, we have to make decisions. Risks have to be taken. At the end of the day, not everybody is going to be satisfied all of the time. I want to thank, I see you. I want to thank you for the opportunity of inviting me here today. Myself, thank you very much. Thank you, Sarah. A great job. She did getting everything all set up and coordinating with us and all those things. Super job. And I appreciated the opportunity to share some thoughts that I hope will help stimulate some discussion for the association and for all those of us who have an interest in protecting our forested lands and managing our own private properties. And with that, thank you very much. It's 12 o'clock.